Right. Yes. So yes, I was doing this research back in Iceland on the processing of rape cases in the criminal justice system, where we're basically looking at if there were underlying kind of social variables that seemed to matter when it came to the processing of rape cases at the different stages. You know, when it's going from moving from the police to the prosecutor's office. You know, are there some underlying variables apart from the legal reasoning that seems to matter? And there were several variables that do seem to matter other than the legal variables or the legal argumentation. And then also when it comes to the prosecutor, you know, when the prosecutor is issuing the charges, deciding if they're going to issue charges or drop the case, there are also underlying social variables that we identified by doing like a content analysis of case. I'm going to go a little bit into that in the presentation. So maybe I should just start my presentation now. I think I'm kind of getting into it already. So I call this expanding feminist justice strategies in cases of sexual violence, and that's kind of summarizes in certain ways the research project that I'm working on now as a PhD student at Sociology of Law at Lund, at the University of Lund. And so kind of my basic thinking at the moment, so I only just started, I started in September last year, so I'm still very much in the beginning phase of my PhD, and I'm still designing my research, and things might obviously change. But my kind of, how I'm understanding it at the moment, at least, what I'm trying to do is to see if we need to rethink kind of feminist strategizing around justice options for victim survivors of sexual violence and how that is possible. And I'm going to base it on interviews with people who have experienced sexual violence and how they understand justice. So that's kind of what I'm going to try to do. Right. So firstly, I'm gonna talk about kind of a little bit the possibilities and limitations of different justice mechanisms or justice practices, depending on what you want to call it. And firstly, I'm going to talk a little bit about the criminal justice system, and that's going to be based mostly on the research that I was doing back in Iceland. But I think many of the issues that came out of that research, I think, apply also in most of the Nordic countries, and in many of the Nordic, some of the issues at least. And then I'm going to talk a little bit about tort law and the tort law option in case of sexual violence, which is not an option, I think, that it seems to be readily available for victims of sexual violence in Nordic countries, but it's more prevalent in the US, obviously, with their legal culture, but also in the common law countries, many of them. And then I'm going to say a few words about restorative justice and kind of feminist critique on that, and also kind of responses to that critique. And then briefly going to talk about grassroots-initiated accountability processes that have taken place in Iceland. Yeah. And then just go a little bit over the research that does exist on the understanding of justice among victims of sexual violence. Maybe first a little bit on, yeah, please.
I was just wondering if you could explain what tort law does that mean?
Right, so tort law is, so we have the criminal law and then we have the civil law, right? And tort is just the, I think it's the American term for compensation law, like damages. Yeah, so I think it's just the American terminology for that, but it's just damages or yeah, compensation law. Right. Yes, and maybe first a little bit on terminology. So obviously in the criminal justice system, and when we talk about crimes, we talk about victims of crimes, right? People are victims of crimes. If we look at the feminist literature around sexual violence and victims of sexual violence, there has been a lot of critique on the concept of victim, because it does indicate an identity of victimhood that many think very problematic, because you might be a victim at some point in your life, but that does not kind of define your existence, right? And this has been developed by feminist practitioners, victim survivors of sexual violence, and scholars as well. and in the English-speaking language, kind of, they use the term victim survivor. Have you heard about that term? Yeah. And I think many in the Nordic countries, when you try to translate that term, it becomes a little bit problematic. I think it's like överlevare or something. It's like offer överlevare or something. And I don't know what you think about it. Maybe we can have a discussion on it after. But I think many find it a little bit kind of difficult. And then also there's critique on that to say, you know, are you then always, if you've experienced sexual violence, are you always then a victim or somebody who has survived the violence? It's kind of about identity issues. So I kind of sometimes use just the terminology people who have experienced sexual violence to try to stay away from these kind of markings. But, and I was actually thinking about it a little bit in the Scandinavian context. I think in Sweden, Norway, Denmark, you use the word offer, right? Victim, offer. In Iceland, we use the word þolandi. I think atola, you know, to endure something, basically. And I was thinking about it. It's actually maybe it's a more interesting term to use, because that kind of indicates, you know, to endure something indicates a degree of resistance. It indicates a type of strength as well. You know, if you endure, you know, it's like endurable tires. you know, there has a reference of strength in it, or cities who endure throughout centuries, etc. Right? So it's just something that I've been thinking about, and I think it would be nice to you know, for a discussion generally, to kind of think about what is the terminology that we want to use, because victim and offer has a very old connotation, right? It's the one who is sacrificed. It's the sacrifice. It's the one who is being sacrificed, which is kind of a strange, conceptually strange in today's understanding of sexual violence, right? Right. So this is probably a very familiar picture to everyone. So this is how the processing of the 189 rape cases that were reported to the police in Iceland in a 2-year period, 2008 and 2009. And I think more or less this kind of mirrors, you know, there's a similar, this table looks similar in Sweden and the other Nordic countries, except you probably have obviously more cases. But so if you just go through this a little bit, me and my colleague who has a legal background, we kind of divided the cases who get dropped or where the investigation is closed, on a police investigation is closed, in 2 different categories. And one is cases are closed due to formal reasons, like statute of limitation, perpetrator too young to be charged or cannot be found, or victim does not press charges. But that's obviously a little bit problematic, because even if a victim does not press charges, if a case comes to the table of the police where there is suspicion of a criminal act, of course the police by law is supposed to investigate that crime, right? But I think this becomes problematic for some reason in the case of sexual violence. And I think it's, many think that, you know, there's a feminist argument to it where you say, you know, you don't want the responsibility taken away from the person who has experienced sexual violence. You know, if the person does not want to pursue the case, the state should not take that decision away from them. But then you can also make a feminist argument from the other side, saying, you know, this is a crime, it needs to be investigated, it is a criminal offense, it is a crime against the state, right? And it should be investigated, it doesn't matter what. So I think the verdict is out on this one, and I don't know how the discussion has been in Sweden, so we might want to talk about that later. And then 31 cases were closed due to substantive reasoning, so basically some form of legal reasoning or of some sort, which usually kind of boils down to kind of lack of evidence or something to that effect. And then 88 cases get referred to the public prosecutor's office. Most of those cases get dropped due to lack of evidence, and we did go through kind of the legal argumentations of why the cases were dropped, and we kind of did like a text analysis of that, and it's basically different ways of saying no proof, no evidence. And then 31 charges issued, 8 acquittals, and then 21 guilty verdicts and 2 verdicts for other kind of sexual offenses. So basically, and this is obviously, this is in the feminist literature, this is often referred to as high attrition rates, like the dropout rates at the different stages is sometimes referred to in the literature as attrition rates. And then another terminology for it is the justice gap. When it comes to sexual violence, this is the justice gap. That's often how it's referred to in the feminist literature. So based on the research that we were doing, and then subsequently I also interviewed people within the criminal justice system, judges, prosecutors, defense lawyers, and independent legal counsel, or I think what you call here something. Right, that one. Biståndsadvokater på norska, I think, yeah. Right, and so on the basis of those interviews and also the content analysis of all the cases that we were looking at, here are just some of the kind of possibilities for reform and kind of development of the criminal justice system, at least in the Icelandic context. And I think maybe many of these points also would apply in other Nordic countries, for example. So one of the first kind of issues is around police investigations, and I think many of the Nordic countries are moving their police training from kind of a police academy training schools to an academic level, and kind of lengthening the period of education. And that's a discussion also that's happening in Iceland. I think most of the Nordic countries are ahead of us when it comes to that. But based on the interviews with police officers or police investigators, a lot of the issues, or what they talked about, they said we need more training, for example, around the interrogation, so the interviewing of both victims and the accused. And I think what makes it particularly problematic in the case of sexual violence is that those accused of sexual violent crimes are usually what they call normal men, right? And that's very different from other criminal cases, where you very often have people with a criminal record or some other issues. But in the case of sexual violence, mostly you have normal men. But actually, and when we were doing the content analysis of the cases and trying to find the underlying variables that seem to influence if cases get referred or not, then one of the variables was that the public prosecutors tends to issue charges against accused persons if they have drug problems, social problems, or mental health problems. So there was like statistically significant difference of how they treated groups of men who had those problems or did not seemingly have these problems, according to the police files. So I think that there is a resistance, I think, in the system when it comes to the boy next door who is being accused of rape. There seems to be a resistance or maybe a lack of know-how when it comes to interviewing them by the police. And then another point is about strengthening victims' legal status in criminal cases to reduce the feeling of re-victimization. And here, actually, I think Iceland and Denmark, in the case of Iceland and Denmark, the victim has no legal status or is not a legal party to the case, to a criminal case. But I think in Sweden and in Finland, you have a bit of a different system where the person is kind of has a kind of a quasi status to the case. And if I understand it correctly, then Norway, since 2008, has the most progressive legislation on the legal status of victims, where they are, to a larger extent, legal parties to the case. And what that affords them is more information at the different stages of the investigation, and also when it comes to the court procedures. And also the possibility of having their own kind of testimonies at court by their own accord, telling what happened in their own voice, as opposed to only being interviewed by the defense lawyer or the prosecutor. And they can also make like a final statement when the case has been processed in the courts. They can make like a final statement. And this seems to be often very important for people to be able to tell their own story in their own voice. Because there's obviously a lot of research on how people who have gone through the criminal justice system, victims of sexual violence, feel re-victimized in that process. And usually it relates to feeling marginalized, not getting any information. Your body is being treated as a site of a crime, sometimes nothing more. You're not a party to the case. You're like a side thing. So this can be important, and at least in the case of Iceland and in Denmark, this could be remedied. And then there's the issue of testimonies by psychologists on the impact on the victim. And I'd be interested to hear what you think about this and how the situation is in Sweden on this one, because I don't know. But in the case of Iceland, increasingly the prosecutor, they always now, I think almost always, when they take a case to court, there is a psychologist that testifies about the impact of a crime on the victim. And when I talk to lawyers about what weight this kind of indirect evidence has, and also the prosecutors, the feeling was that yes, it definitely has impact when it comes to the compensation claim, right? The compensation claim is in the case, so if the accused is found guilty, then they discuss the compensation claim, and then the psychological testimony is important to that effect. But does it have direct bearing on the criminal case? That's the question. And according to those I interviewed, they're saying basically the better these testimonies become, the more weight they have. So as an avenue for strengthening that type of evidence, or giving more weight to that kind of evidence, this might be a strategy to kind of build up a strong kind of base of expert psychologists in trauma and post-traumatic stress disorder, etc. But I think there's a flip side to that also, because that means that we leave it to the psychologists to decide who is the victim and who's not the victim, and how a victim is supposed to be and supposed to behave and supposed to feel. So I think there is kind of a trade-off in there. But I think it's an interesting thing to think about. And then it's the question of negligence and intent. You might have had that discussion already, right? So in Norway they have rape by, I think it's gross negligence, I think in Norway. And I think it's the only Nordic country that has that in their legislation since around 2000, I think. And obviously, what they say, the judges, etc., they say, it's very, very difficult to prove intent in cases of sexual violence. So then there's the question of negligence. If it makes it easier to prove, is it easier to prove negligence than intent? But then, of course, the sentencing would be much lower. That would probably follow. But that might be something that needs to be looked at better. But my understanding is, though, that in Norway they don't use it a lot. There are only kind of special cases that are understood to fall under gross negligence. And then, at least in the case of Iceland, it's quite interesting to read about, like in textbooks and in books that law students read, and articles that are produced by legal scholars, when they talk about the competencies of a good judge. What is a good judge supposed to be able to do? And the good judge is supposed to be able to, of course, know the law very well, in a wide sense and a deep sense, and be able to apply the law in that general manner. But then a good judge also needs, at least in the Icelandic text, good common sense, or if we translate it directly, healthy common sense. And this, I think, I don't know what you feel about it with a law background, but from somebody with a social science background, this sounds very interesting, because common sense is very, very difficult to define, right? What is common sense? And usually, you would say common sense is basically the belief held by a dominant group in society at any given time, right? And if the dominant group has another understanding of common sense than other groups that are not dominant, then obviously we have a bit of a problem, I would say. And when I talk to judges about this, how do they develop their common sense? Is that something I ask them? Is that something they teach you in law school? Common sense. How do you? And then they said, no. That's just something. You have to be born with it, or you have to be lucky. With the gifts that God gives you. So that kind of made me understand that I think that's an element that is not reflected upon a lot, and I think. That's definitely something I think judges would benefit from, to reflect on what is common sense and how do you determine that. Right, and then a few words on the legislation. I know that you guys had a session on the whole lack of consent debate, right? So you probably can tell me more about that at the moment that I can. But of course in the literature there is this continuous discussion on if the legal definition of rape should be framed on the basis of force or the threat of force, or if it's supposed to be lack of consent. And yeah, I would love to hear what you say about that after your last session. But it seems to me that it doesn't matter really how you turn it, or at least like I posed the question, to what extent does the formulation of the legal definition of rape matter in the face of high burden of proof in criminal cases? I think that is more of an issue than maybe the framing of the article itself. Because obviously the common law countries have had the framing around lack of consent for 30, 40 years, I think now. And their conviction rates are not any better than the Nordic countries. So I don't know. But there's also some talk in the feminist literature about the developments in the kind of international criminal law. And both from the criminal tribunals like the Rwanda Criminal Tribunal, where the concept coercive circumstances came up. So when there is rape under coercive circumstances, where the circumstances are such that there is not a question of consent or not consenting due to the circumstances. And I think that might be more of an interesting avenue to look at, to tell you the truth, and to develop that concept more. And to my surprise, actually, when I was doing this research back in Iceland, we had a reform of the sexual offenses chapter in the criminal code in 2008. And there we find this concept here. So this is the Icelandic penal code. It looks more or less, I think, similar to the Swedish one. Apart from this other unlawful coercion section, and I think this is not, this is the Swedish one, and I can't find anything that might capture this, but I don't know what you guys would say, but at least in the Icelandic one we had this other unlawful coercion, and this terminology actually belonged to another article in the sexual offenses section before they reformed it, and it was taken out of that article that was almost never used and put into the rape legislation, or the rape article. And when I was talking to the prosecutors in Iceland, and I was asking them, what does that mean? And then they said, yes, this was a concept that was in this old article that we never used, and now it's a part of the Rape Act. We are basically just starting to try to interpret it in different ways, just to kind of create case law on it, basically. And they said we're trying to interpret it in a way that it indicates some kind of structural inequality, or some kind of, for example, age difference, or some kind of a difference in abilities, or contextual circumstances, like when the rape happens in a car far away from everybody else, where you have like insecure circumstances. So this is what they're trying to do, seemingly, in Iceland. And I think maybe in practice this might be a more fruitful avenue than the whole force, lack of consent debate. I don't know, but I look forward to hearing about what you discussed afterwards on the last seminar. Right, and now if we talk just a little bit about tort law, so like I said a little bit earlier, referred to earlier, is that in many common law countries, it's not uncommon that victims file compensation claims in case of rape. And actually in the US, this is obviously done much more. They have a very strong legal culture and they use the legal system a lot. And then even they have, in a kind of a typical American fashion, they would have a compensation claim against a third party. So if the rape happens in a mall, for example, then you go and sue the mall, right? So, but that's obviously the American context. But there are also perpetrators or accused persons that have been sued in this kind of way also. There are also quite a few cases in Canada and in the UK as well, and in other common law countries of this. And legal scholars who have been kind of looking at this as a possibility, they talk about several elements that are favorable or can be positive in using tort law. It's firstly that the plaintiff is a full legal subject and has control over the proceedings and the action, and that can have empowering effects on people because they're controlling their own case and they have their own lawyer and they're in charge, and that can be important. And then, of course, maybe the most important thing, the standard of proof is lower. And I don't know, I think my understanding is, in talking to Swedish lawyers, that that actually might not be so much the case in Sweden, that you have much tighter, when it comes to your kind of tort act, that it's much more difficult to sue for violations in tort law in Sweden, because it's narrower, the definitions are narrower. And then there is the thing about civil suits, you know, even if they're intended for private wrongs and criminal law for public wrongs, it might not necessarily be such a strong distinction in practice. And if we would have several such cases, it might send out a signal to the general society. It might not be just private in that sense. But the negative aspects, the question is obviously, does that undermine the seriousness of the crime? That's always, when you start to talk about processing cases of sexual violence outside the criminal justice system, then there's always the risk of, are we undermining or somehow diminishing the seriousness of the crime? And then also it's a financial risk, obviously, to take a private suit. But I think actually that's just a question of policy, because I think in Nordic countries, we have these pots of money for kind of state support for court action, but I think usually you have to fulfill very certain criteria to be able to apply for that kind of funding. But that's just a question of policy. It's possible to widen that and include people who experience sexual violence to be state supported in filing a suit, compensation suit. And just to say that in Iceland we have one case where a woman was assaulted by 3 men, and she reported the case to the police, and they basically botched the investigation. Because the men were 3, and instead of taking them all in for questioning at the same time, they first took one, and then they let him go, and then 2 days later they took the other, and a week later they took the third. And of course they had just corroborated, the stories had been synchronized. And then the case was sent to the public prosecutor's office, who dropped the case because of lack of evidence. The woman tried to have the case taken up again, but that did not work. And then she went and filed a compensation claim. And she won the case based on the Tort Damages Act, which stipulates that compensation may be awarded for personal injury from unlawful wrongdoing, which breaches the freedom, peace, honor, or person of the victim. So this is the Icelandic Act, an article on that. They appealed, and she won the case also in the Supreme Court. So I think this is interesting, because here the burden of proof is different, etc. But of course there is no punishment in that sense. There is no prison sentence. And then in Norway, and this is interesting. Did you guys know about this? That in Norway it's actually not uncommon that the compensation claim in a criminal case is reviewed completely independently of the criminal case. So you might have a not guilty verdict in a criminal case, but then in the same case they might find the not guilty person liable to pay damages.
Sorry, I'm not a student of law, so that's my question is that if they are sentenced in the compensation claim, will that go on their permanent record or anything? Like,
No.
are they, no?
I don't think so, no. This is because it's not criminal. It's not a public offense.
Okay.
So it's just a private suit between individuals. It's like contract law and things like that. So it's not at all connected to the criminal field.
So in that sense, is it still seen like as a rape in that sense?
No, that's the thing. You would have to formulate it in other terms. You could not really call it rape, because rape by law it belongs in the criminal legal system. So you would have to formulate it as a violation or this kind of formulation. So a personal injury and kind of sexual freedom, for example. You could talk about concepts like that. So it's so you could not really call it rape.
Okay.
Yeah. Which can also be problematic, obviously.
Yeah.
Right.
Are they treated in the same process, even though they can be like the result can be different? Because in Sweden, that they would be like processed together.
Right.
And does that happen even though the result would be separated?
That's the thing. And this is what's very special. I think this is very particular to Norway. I don't think any other Nordic country does this. So you have just a standard criminal case, and you have the compensation claim as a part of that case, And then when the judges look at the case, they can find the person not guilty, but then like 5 minutes later, in the same case, in the same room, say, but he's liable to pay damages, because the burden of proof is different. So it's completely obviously counterintuitive and makes no sense. And there's I've been reading some news kind of coverage on this, and you can just hear the tone in the report. What is this? What kind of this is crazy, and the courts are completely crazy, and it doesn't make any sense to any normal person to do it this way, and kind of quoting victims saying, what does that mean? So it is obviously very counterintuitive, but by legal rules of this different burden of proof and different types of cases, you could have that. You can have that outcome, but this Norwegian practice, it has been challenged several times in the European Courts of Human Rights, and Norway has lost on that account, a few times. But at the same time, the European Court of Human Rights always says, it's not, this practice in Norway is not a problem, because we do have the criminal standard of proof and we do have the civil standard of proof. And that is not a problem. And it's not even a problem to deal with it in the same case. But it's all about the wording of the case. So when the judges are writing their verdict, they have to be very, very careful how they formulate the language of the verdict. It needs to be very, very clear. They cannot refer to a criminal act when they're making the verdict on the compensation. So it's all about, it's a bit of a language game that needs to take place there to make a very clear distinction between the tort and the civil case.
Has it been the accused that has
Yeah.
to...
So it's the accused who's been, sending it to the Human Rights Court on usually the basis of Article 6 of the Human Rights Convention, paragraph 2. Everyone charged with a criminal offence shall be presumed innocent until proved guilty according to law. They're claiming a violation on that one. I think for law students, I think it's a particularly interesting problem from a law perspective. Any questions or comments on this? Okay, so then if we go into restorative justice, so firstly, when people talk about using restorative justice in case of sexual violence, and just people who are working on restorative justice, they usually try to make a very strong distinction between restorative justice and mediation. So you would have mediation is traditionally something similar to a civil suit, where two people are fighting over something. It could be a contract, something akin to a contract, or a land, or some dispute, right? And usually mediation is settlement driven. So it's all about, the outcome is supposed to be some kind of a settlement that both are happy with or content with. But when you're dealing with criminal cases, you're obviously, it's not about settling anything. It's not, it relates to somebody did something bad to another person. It's not about a breach of contract. And so those restorative justice practices are usually said to be dialogue driven. So there is not necessarily there is no specific outcome stipulated. But there have been, but this is very problematic because there's loads of restorative justice models out there, and this has been kind of developed since the 70s, I think in Canada, and originally it was kind of faith-based groups who used the concept of restorative justice, and it was kind of linked to kind of religious beliefs about forgiveness and reconciliation, and try to be good to each other and find a good solution to things. And this is obviously very problematic in case of sexual violence, and this is something that from a feminist perspective has been criticized a lot. So now right, I think I'll just stop there, but just to say that there's a lot of different models on restorative justice. And in many jurisdictions, it's actually forbidden to use restorative justice in case of sexual violence, right? Because the case of sexual violence are deemed too serious to put in such a process. But in other jurisdictions, it is being used, but the problem is that there are very, very few evaluations that have been done, so nobody really knows how this is working. And here's just some critique on restorative justice in cases of violence against women from the feminist literature. So basically, first of all, is that the restorative justice literature lacks an understanding of the dynamics of violence against women and gender inequalities that shape these dynamics. So they don't have this kind of power analysis in place, like structural inequalities. And then there are some really bad experiences from kind of these court sponsors mediations, where women were almost forced, not forced, but pushed to take part in these kind of mediation / restorative justice practices, where facilitators were not very concerned about their safety, but it was much more about, how can we ensure that the perpetrator is, forgiven, so he can go back into the community to minimize the risk of reoffense, right? So that's kind of the restorative justice, the motor of the restorative justice traditionally, historically, way of doing things is how do we make sure that offenders do not reoffend, right? So you have to face your community, you have to face the person who victimized, and through that process you're supposed to kind of take responsibility and therefore reduce the likelihood of reoffending. So that has been kind of a primary issue for many. And then often the victim is often kind of sidelined, is not kind of a key, does not have a central position in the process. And then there's also the assumption that in restorative justice that victims are angry with their offenders. And this is obviously very often not the case in case of sexual violence, where we have blame and shame as a very prominent feelings that victims experience. And therefore there are concerns that if you put people into the same room, you could end up kind of re-victimizing the person again, because they might just take responsibility for everything through that process. And then, of course, finally, there are concerns about cheap justice. So this is, if we're talking about serious crime, for example, like rape, putting that into a restorative justice process might be cheap justice, easy way out for offenders, and does not send a strong signal to the community. But there have been, though, kind of, yeah, please.
What kind of violence were these cases about? Was it sexual violence or violence
It has
in
been
a relationship or?
the bad experiences part.
No, this is like where you said that it was more about like keeping the offender from re-offending.
That's been kind of like the development of restorative justice comes a little bit out of that notion. So that's kind of the historical roots of restorative justice, so to speak. So kind of the aim of restorative practices, restorative justice practices, when they were being developed in the 70s, was very much about how do we ensure that offenders do not reoffend, and how do we integrate them again back into their communities. That was very much kind of the focus.
But was that discussion talking about, like, were they talking about violence against women particularly?
No,
or?
no, and that's the thing. That usually not. There was other crime, the other kind of, theft and other types of violation kind of crimes. But I don't think sexual violence was very much on the agenda to begin with. I think I'm right on that. So that's more of a recent kind of discussion. Although, again, there are so many restorative justice models out there, and there's so few valuations, so that this might be happening, but we just don't know about it. You know what I mean? Like, there might be have been restorative justice processes in case of sexual violence for a longer period of time, but it's nobody's really monitoring all of these programs.
I was thinking that if it would have been about that kind of situation, often like violence against women is coming from someone close, and the person that they would like reoffend against would probably be that same person.
Exactly. And I think these court-mediated, these kind of bad experience in particular, these court-sponsored mediation, this was in domestic violence cases. So that's obviously highly problematic if the victim's safety is not being secured in such a process. Really problematic. Yeah. Right. Now for the past, I don't know, maybe kind of 15 years, there has been more discussion about the possibilities of using restorative justice in cases of sexual violence. There are some kind of feminist thinking restorative justice scholars that have been writing a lot about it. And I think some of the key names are Kathleen Daly. She has written quite a lot, if you're interested, and also Mary Koss. They're trying to see, how restorative justice can fit for these cases. And they talk about the importance of, for example, the victim or victim survivor, or what we want to call it, to be informed of their options, to be able to participate and ask questions in the process, so being part of the process, and also being able to initiate the process, being able to say, no, I don't want that process, to have ownership, basically, is very important. And then to have a voice and to be able to tell in your own words what happened is very important. And then to have the experience validated, to be believed and not blamed. And then to be vindicated in some form, either by the legal system or the community, some form of vindication. And then there needs to be offender accountability in some way, in some sense. So these are kind of some of the key tenets of the restorative justice models that they aim for. And I think probably one of the most exciting restorative justice programs out there is Project Restore, which is both in the US and also in New Zealand. And they are seemingly doing kind of very, they basically designed a restorative justice model specifically for victims of sexual violence, and taking in all the feminist critique, incorporating that in their model, and really trying to see if this can work. And they just recently came out with an evaluation of the project, but only of 22 cases. And the findings are, there are some positive indications in the findings. And maybe don't need to go through this. You probably just, any questions, maybe? Right. How am I doing on time? I think I'm probably... Yes, I've been talking for 50 minutes. You want to give me 10 minutes more? Is that okay?
Yeah.
Right, so restorative justice in the Nordic countries. So basically, it's being used in Denmark, and has been used for quite some time in Denmark, and is now facilitated by the Konfliktråd in Denmark. And they have these only 23 cases for a 5-year period, which is obviously not much. But seemingly the facilitators, they only get a week's training, and they don't get special training on sexual violence cases. So that's not very encouraging, I think. And there's no research or evaluation that's been carried out on these cases. And in Norway, they're doing a pilot project on restorative justice, or what they call facilitated dialogue. And the Konfliktråd in Norway has also handled cases, mediation in cases of sexual violence. And this is a bit tricky, because this is very often called mediation. For example, this VOM, victim offender mediation, it has the word mediation in the title, but at the same time, it is supposed to be a restorative justice process. It's not mediation. It is a restorative justice model. But I think it's very important to make the clear distinction between the two, because mediation calls for a whole other conceptualization of what's going to be happening. And then the Swedish Forum for Mediation and Conflict Management officially does not do mediation in case of sexual violence, but there was recently an interview with the head of the organization, who said that they do sometimes do mediations in cases, especially when it's young people experimenting with alcohol and drugs, as it was said. And I have to look at that a little bit closer. I don't know how, if people are trained, facilitators are trained especially for that, or how that's being done. It doesn't happen in Iceland, and I don't have information on Finland. Right. Any questions on restorative justice? No. So then I wanted to tell you briefly about accountability processes in Iceland. So basically, in 2011, we had the first accountability process initiated, as far as I know, in Iceland, and it was an Icelandic woman who talked to her friends and in her community, feminist community, and who had experienced sexual abuse in a kind of an on-off relationship with a man in Iceland. And they started to read up on what anarchist groups are doing in the US, because anarchist groups, of course, do not want to have anything to do with the state, so they had to figure out their own solutions for their own problems within their community. And for case of sexual violence, there is kind of models that have been developed there. So they basically looked at these models, and then they took some components of them and kind of created a process that took place in Iceland. So, the reason I can kind of talk about this is because it hit the media. So because the responsible person, the man who was responsible for the violence in that case, blogged publicly about it, and blogged about being responsible for the violence. So it hit the media, and then there was a lot of media discussion, and in the end, she also was interviewed with her full name in the media about the process and why they went ahead with the process, etc. And it's a long story, and I don't really have time to go into it in details here. But basically, and I think there were around 3 other cases that were subsequently initiated. But based on an interview with her in the media, she was asked why she didn't go to the police. And she said, "I have too often witnessed people having had bad experience of the criminal justice system. The system is ill-prepared to deal with these cases. I did not want to go through the system and did not want some official system defining my experience. I know what happened, and I'm not searching for an external approval of it." So, and I think for me, this case kind of made me very interested in alternative ways of approaching justice. Because this is kind of an example where people want to make their own definition and pursue justice on their own terms. And I think that's very interesting. And so what she did was she wrote a letter where she described what he had done to her. Then she asked his friends to read the letter over and take it to him and be with him while he would read the letter over. And then he had the option of accepting her description of the events, 1, and then 2, accepting kind of a list of demands that she put in the letter. And the demands were that he would not contact her, he would not be in any kind of contact with her, and that if they would ever find themselves in the same place, that he would leave the premises, so she would not have to leave the premises, and that he would get help, so he wouldn't offend again against another person. And also because he's a human rights activist in Iceland, that she wanted him to reconcile what he had done to her and then his profile as a human rights activist. So that's kind of some of her demands. And he accepted those demands. So the first blog he wrote about this, he said, "I have committed sexual violence. I have subjected another human being to violence without realizing it, without intending it, without seeing it. And this blindness was a part of the violence." In some ways, this might be seen as some kind of a success story. But this is not the whole story, because afterwards it kind of spiraled a little bit out of control, and the media was kind of involved, and then there were friends and family members that got involved, and there was a lot of criticism on the process. That there was this criticism, there are these crazy feminists who are just creating their own justice system somewhere out in society and being the judge, jury, and everything on these cases, and so the process by many was not considered legitimate. But on the other hand, it's interesting to look at this case from the perspective of restorative justice, because I think many of the elements of restorative justice process are actually in that case. But because it was homemade, it's a homemade process, the process was not deemed legitimate. And this is my reflection on it, and I think it's more to do with how difficult it is to take responsibility for sexual violence. There is no discourse in society that you can hang on to. You have the discourse of the victim has been established, right? We want to support victims. We want to believe them, we want to support them, and we want to help people get over it. There's an established discourse on that, and what it means to be a victim, etc. Right? But what does it mean to be a perpetrator? Right? It's I think the perpetrator of rape. I think in many of our heads, it's the monster. It's the person that needs to be excluded. Nobody wants to talk to somebody who's perpetrated such an act. And you have research, recent research from Iceland, young kind of kids talking about, if my friend would ever commit rape, I would never speak to him again. It's considered such a serious act that you're ostracized, right? You're excluded. Nobody wants to kind of be involved with it. But at the same time, we know it's a very, very common crime. It's a very mundane, everyday crime that a lot of people have experienced, mostly women, right? So I think one of the reasons this kind of, in many ways, went out of control, this case, is one, because the media kind of got into it, and also because this is such a difficult issue to tackle. Yeah, but it's a long story. And note just this is the final slide, and here is just some of the research that has been looking at justice. What does justice mean for people who've experienced sexual violence? And this is along the lines that I want to do in my research, because there's not a lot of research on it. So there is this research from Herman from 2005, and she took interviews with people who experienced sexual violence and domestic violence, and she summarizes it like this, that they wish to see their offenders exposed and disgraced, not for the purpose of getting even, but rather for seeking vindication from the community as a rebuke to the offender's display of contempt for their rights and dignity. So this is kind of one formulation. And then Julie from 2006, victim survivors spoke of justice in ways that reflect the goals of restorative justice, but they were reluctant to endorse restorative justice as a paradigm within which they would pursue justice. So their formulation was very much in that kind of direction, but they did not see restorative justice as an avenue for them. And then McLean now in 2014, and she talks about the concept of kaleidoscopic justice, and kind of problematizing how complex justice, definition of justice can be for people who've experienced sexual violence. And it changes, and it has no clear beginning or end, and it's a shifting pattern, lived and ongoing, and experienced differently over time. And includes all kinds of things, like some kind of punishment, but also to have a voice in a process. To get support is also formulated as a type of justice, and many other factors. Justice can be a lot of things, and it can change over time and be different things at different times. Right. Thank you so much. So, any thoughts or comments or questions?
I was wondering if this case in Hildur and Hildur?
Sorry?
I was wondering if this Icelandic case,
Yeah.
has there been more, like, have other people been inspired by it?
There were at least, I think according to the media, there were at least 3, I think, other cases or processes initiated. Yeah. And I don't know anything about them. That has not gone into the media. And even if I'm referring to this media case, but I should also be transparent and say that Iceland is obviously a small country. But I was involved a little bit in that process, very much marginally. But I know the people who were involved, and I supported some friends that actively participated in that process. But the only thing I'm talking about here is something that came out in the media. Yeah. But so 3 other cases.
And in all those cases, the perpetrator has to accept to be part of it, and how does it work?
Yeah, so this is a little bit the difference between kind of homemade justice processes, like these grassroots initiated processes, and then restorative justice processes. Because in the restorative justice process, you have a recognized, like a program, you have a framework, you have facilitators, preferably trained ones, and everybody knows what they're going for there. And then, for example, a victim can go and say, okay, I want to initiate a process, and then the responsible person has to be contacted, and that person has to agree to take part, right? and that person might not want to take part. So then that would be it. There's nothing else that can be done. And if that person agrees to take part, that person needs to acknowledge responsibility to some degree, because otherwise you can't really initiate the process. Because it's not about, it's not about everybody just saying their opinion about what happened and then finding some kind of a common ground. That's not what the process should be about. It needs to be very clear that the responsible person needs to take responsibility for their actions, and that people might not want to do that.
Thinking about the responsibility part in this Icelandic case, because I felt like he took responsibility for it, but also tried to excuse himself because he didn't intend it. And I don't see the responsibility taking.
You mean in his words?
Yeah.
Here.
Like without realizing it and telling it.
Yeah, it's kind of, and it is interesting to read, because he blogged quite a bit. I think there were like 4 blogs on this, and it's a tremendously interesting read. It's such an interesting thing because you can see how he's struggling with it. He wants to do the right thing and take responsibility, but at the other end, he is having huge problems of taking responsibility at the same time, and it's interesting to see, because he's a writer, so he can very well express himself through text, and it's interesting to read about his reflections on how he doesn't really want to, in a cafe he would not want to sit beside the person responsible for such violence, and now he has to sit with himself being responsible, and he doesn't want to be with himself anymore. It's complicated, and he kind of goes all over the place. In some of these blogs, he's angry, he's criticizing the process, he thinks it's all not a legitimate process, and in some parts of the text, he's trying to kind of redefine what really happened. It wasn't maybe that much of a violence; it was more maybe kind of mental abuse that took part in that happened in a sexual context. So he kind of goes all over the place on it, but also he does take some responsibility. But it's fuzzy and it's all over the place. It's problematic.
But Björk was happy with the process.
Not all of it, not all of it, but many elements of it, I believe. Yeah, many elements of it. Yeah.
But it is an interesting process, because I think a lot of times the victor/survivor of a sexual offense would like to, for the person that has committed a crime, to actually take responsibility. I mean, because in the legal system, you can be coerced to take responsibility because you can be convicted. But a lot of times, I'm not a student of law, but I'm very interested in this subject area. But still, a lot of time when you read how people, how sexual perpetrators are expressing themselves about what happened, there's a lot of explanation taking place that has nothing really to do with the crime, and there's a lot of aspects taken into it that that make them themselves acquit themselves of the crime. So it is really, really interesting, but at the same time, it is a very interesting process. But at the same time, you won't get the same result, as in that person will have to go to jail or something.
No, exactly.
But from your personal view of this, how do you see, what would you like to see happen within law, within the frames of law, when it comes to this, the process of making this better, in the Nordic countries?
Well, I think like we were talking about a little bit outside before we started. I think the big problem here is that we're dealing with sexual violence. So for example, rape as a type of sexual violence. You know, it's the second most serious crime that you can commit according to law, right? It's homicide, and then there's rape, right? It's an extremely serious crime. But at the same time, we don't have homicides at the same rate as we have sexual violence. You know, sexual violence is so common, right? It's so common. And I think there's like a fundamental, almost like a schizophrenic kind of situation that, and I think there's no way, you know, even if, like from a feminist point of view, I would love to say, you know, yes, we just have to get all of this through the criminal justice system, you know, kind of, but the criminal justice system will never be able to process all of these cases, because at the same time it's like a social issue, right? It's an endemic. It's everywhere.
Like 1/3 of the world, like of women of the world, have experienced sexual violence.
Exactly.
So I mean, that would be putting a lot of people to jail.
That's a lot of people in jail. Yeah. You know, and I just don't. It's not a viable. It's just not a viable strategy. You know, I think it's so much to do with attitudes and all kinds of other. It's almost not a deviant behavior. You know, it's like crimes is some kind of deviant behavior, right, according to criminology. But it's so common that you can't really categorize it as a deviant behavior. It's a commonplace behavior, and therefore we cannot only use the criminal justice system to deal with it. I've kind of come to that place now, I guess, a little bit. You have a question? Did I answer that?
Yeah, I mean, it's interesting because this is an interesting perspective that I have never really it's never been presented to me. So
Yeah.
I think it's interesting to see, like, because you are absolutely right. I mean, there's just such a huge amount, and especially like acts of violence committed in type of gray zone, which is really, really hard to get any justice from that.
Exactly.
And if the perpetrator is like open-minded about accepting some kind of responsibility, I still think that would be like a part of a healing process for a lot of people that have been victimized.
Exactly.
So yeah, it is really, really interesting, but it would be interesting to have like some kind of institutionalized, framed type of thing that would that could help with those kinds of stuff.
Yeah.
Because, I mean, obviously this was in this case they were themselves working within the frames of human rights and stuff like that. So there might be another network to actually go about creating this kind of process. So it would be really, really interesting in that type of, like, from that type of sense, if you're
Right.
going to like create some kind of more institutionalized form where you can actually find some kind of, you know, this type of justice.
Yeah. And I think also on that note, I think it's so important also that people who have experienced sexual violence participate in creating these processes, because I think those are the experts, and these are people who need to participate in you know, what is viable, what, you know, how can we kind of push at different places. So I think that's enormously. I was going to say something else. I think that's enormously important. I lost it. If I remember it, I'm going to come back to you. But okay, you and then you, yeah?
Yeah.
Or yeah.
I was wondering if you think that this whole media spiral and it got a little bit out of control, but did it kind of trigger a discussion, like in society, about what is sexual violence? Because like this kind of fog, like what he wrote, it's kind of like not taking responsibility, but at the same time maybe it's broadening the view of what is sexual violence. Like maybe it's not this picture that we have of it, which is like a stranger in a park and
Yeah.
some crazy person. Like maybe did it open up a discussion about, like, it can be in a relationship and it can be other than what we
Yeah.
expect it to be.
I think, like, in many ways, like, that understanding is already there, that like rape is not only, you know, the stranger in the bushes. I think, like, we've gotten to the place that we know that it's, you know, it's much more commonplace than we thought, right? Like, I think generally we've kind of gotten to that place. But I think we're still at that place where we have a lot of victims, a lot of victim survivors, but no responsible people. You know, because the responsible people are somehow, you know, because we haven't really gotten to that stage yet. And I think what's interesting about this case is because he does in some form, in some way, take some responsibility. And also because he's a semi kind of known person, especially in a certain kind of communities in Iceland, and he's, you know, human rights advocate. He's an author. He's a person that, for example, many men on the kind of left wing, you know, of kind of society would identify with. You know, he's a nice guy. You know, he's a very nice guy. I know him. Like he's an old acquaintance. I haven't talked to him for a long time. And he's a good guy. He's a nice guy. You know, and that's, we have to get to that place. You know, that those are the guys also who can overstep boundaries and commit violations. And we need to be able to create also a place where it's possible to take responsibility for it. Because for me and how I see it a little bit, he's kind of, you know, he's trying to find like a discourse for it, right? But there's nothing there. There's nothing to hold on to. Because I think it's an identity that is at the moment kind of impossible, right? To be a perpetrator of sexual violence. It's an impossible identity to have, right? But we need to get to the place where that is possible, you know, and it's possible to take responsibility for it and work through it and get to another place. So, sorry, just, yeah, you?
Yeah, it's related.
Okay, yeah.
How do you establish such a discourse, and do you have any suggestions how to do it and who to do it? Because I'm thinking if it's a thing for university, or if it's rather for grassroots movements to begin with, or because this is such a rejected, even like beginning to touch is very rejected. So how do you do that?
That's the $1 million question, I think. I honestly, I don't know. But I do think at the same time that even if these accountability processes, and so you want to add to that? Or?
Yeah, because if you look at on the other hand, in other cultures, you have the same problem with creating a discourse about the victim. For instance, in certain places in India, it's really hard to.
Right.
There's the shame culture, or whatever you want to call it.
Exactly.
But how do you do it there?
Right. And also, like in the West, somehow in the West, the feminist movement, the women's movement established a discourse around victimization of sexual violence, and women's shelters, for example. There are a lot of things that it can be done. We know that we can change society. It's just a question of like how do we do it? And I think that's just a very, very good question. But I think this case, for example, even if it was messy and even if it left a lot of people very upset, at the same time, it did push the boundaries, and it did make, for example, because he's an author, for example, and he's a lot of friends, authors, and now there are at least 2 novels in Iceland that refer to these accountability processes. And it's a whole other story, but you can see how men are, to some extent, seemingly identifying with this, because it could be them, right? All of a sudden, it could be them, because the one who is found guilty in the criminal justice system, that's not me. That's a criminal. That's somebody else, right? But in this case, this is somebody. It could be me, right? So. I think that is important. Just the kind of, it's about raising a certain level of consciousness, right? To just create possibilities, like when it comes to. But how do we do it?
Yeah, who's gonna say this is a start with its restorative justice programs, but have you do it? Can you do it from a more with taking on from a more from institutions that have more power? Because this was individual initiative, as
Yeah.
I understand.
Well, I think then you can, of course, that's what I think restorative justice programs can do. Because I think to some extent they do this in a more formalized manner. So there you have, you know, it can be a state-run restorative justice program with trained facilitators, you know, state-funded, you know, so you can create a framework like that where you would have restorative justice. But then it's very important that the model is sensitive to victims' needs. You know, the victims' needs are at the center of that model and not the marginal phenomena.
I had a comment
Yeah.
on that.
Mhm.
There is a project called Fatama,
Yes, I think
and
heard about
I
that.
think they are trying to create this kind of discourse
Right.
about like male responsibility and like talking about the perpetrator's responsibility instead of like the victims.
Right.
Like focusing on the victim.
Right.
But it's a kind of new project. I think it started last year, so I don't know how it's going.
Yeah.
But I think that is an attempt, and that would be on a grassroots level.
Right. Right. I think the grassroots is going to play a very important part in this. I think because I think it needs to come from the grassroots. I don't see how it can come anywhere else. But I think like the state could assist, for example, with developing restorative justice programs. So, yeah.
Do you think that people refuse to take responsibility because they know that they will get away with it if it comes to court? And then they are like, if I don't take responsibility, I don't have to do anything. But if I take responsibility, it's this you are a rapist or you are.
Yeah.
It's
Well, I think it's probably at least two things. Firstly, if you take responsibility for sexual violence, that's a very serious crime, and you can be locked up in jail for a long time. Not so long actually, but you'd be locked up for that. So I think, you know, for your self-preservation, not many people would say, "Oh, I committed that offense, so just put me in jail for a couple of years, and I'm taking my responsibility." That's, you know, very unlikely that that's going to happen. And because of our legal system being very adversarial, right? So immediately when you enter that system, it's all about having a defense lawyer, making sure that, you know, you get out of that as unscathed as possible, right? With minimum. So the system is already geared towards making sure that the person does not accept responsibility, right? Like from the get-go almost. But on the other hand, I think also in the case of sexual violence, I think it is about being a rapist, having the identity of a rapist. I think it's almost psychologically is an extremely difficult identity to have, right, and to take on and to work through. And we don't really have, at least in the public discussion, we don't really have any examples of how you do that, right? How do you do that? I don't know. So I think it's probably like a combination of that, but also probably other factors as well. I think.
I don't know. God, I like so many different threads right now. Okay, so my background isn't legal. I'm studying law right now, but I wrote my bachelor thesis in gender studies on this subject.
Okay, right, fantastic.
So I have like sort of taken part in the problematization of the victim, like definition of victim survivor discourses.
Yeah.
And I really don't think that that the discourse about the victim is sort of done and safe either. And I find it problematic that we think that taking responsibility for being a rapist is like directly connected to being prosecuted for it or being
sentence for it, because there are a lot of examples of men who have taken responsibility and sort of even bragged about it. And when we
Right, in
refer
that
them
way.
to the legal system, which are like, I'm sorry, but I'm us who have most of us don't have that sort of competence to, and I mean I can look around and see my classmates and think, yeah, I understand why this doesn't change anything.
Mm-hmm.
I mean, and it's sort of like connected to your question, that where do we start?
Mm-hmm.
Who's taking responsibility for if the legal system is supposed to sort this out, then the legal system has to be competent enough to do that. And I really don't know if I had a question, but I'm just sort of wanted to say something. Hear my own voice.
No, I absolutely agree with you. I don't think we're there yet when it comes to the discourse on victims. No, I absolutely agree with you. But I do think, and actually this case was I thought it was interesting because there was so much commotion around the grassroots initiated accountability process. And I was always waiting for a direct attack on her, the victim, right? But you could see how people, really angry people, tried as much as they could not to blame the victim, right? You know what I mean? And it was interesting, but I think she was blamed, in kind of indirectly, and because of the blaming the process, blaming almost everything, but not really kind of touching her person. At least if it would have happened 20 years ago, I think the discourse would have been completely different. So there has been development. I guess that's what I'm trying to say. There has been development on the discourse around the victim. I think there is much more awareness now what that means, and not to blame people who've experienced just sexual violence, etc. But I agree with you. We're not there.
And I really agree as well. Of course, there's a difference, but I'm thinking that the problem is kind of related to the common sense problem. That is who if the judges or the people who work with this, what are even though they know that, okay, I can't specifically blame the victim, that's still people who still have those. There are no such thing as objectivity, and
except if you're a judge, of course.
Yeah, exactly. And if we don't open up for discussion in the legal system that there are no objectivity, we sort of get taught that we're supposed to be objective, and that's just it just doesn't exist.
No, absolutely, and it's interesting to hear law students, what you think about that, and if legal education has been changing in that regard, is there more reflection of on, that it's impossible to be objective? No, when I was doing the interviews with the judges, you could see it was very interesting. The judges are obviously different, right? Some of them are much more kind of advanced in their thinking than others, obviously, and as everybody else, right? And it was interesting. For example, there was one judge I was talking to back in Iceland, and he would refer to, we have come such a long way in the criminal justice system. There has been so much public debate about sexual violence, and this has educated us here in the system. And there are cases that are going through now that would never have gone through 10, 15 years ago because we have developed. So there is this understanding of developing with kind of the public discussion, right? But at the same time, when you ask somebody else, you might, they might say something completely different. They might say, public opinion is having way too much influence on the verdicts, and we have to stick to the law, and we cannot let this sway us here back and forth, and so. But yeah, I totally agree. I do think that more reflection should be encouraged in legal education. I absolutely agree with you. And also in just adult education that, for example, judges and others, continuously go and re-educate themselves, and because today's common sense is something completely different in 5 years' time, right?
Yeah.
Oh, yeah.
Timing. Do you have any reflection on the Swedish? I actually don't know the word for this in English, but we have sort of a jury system.
Yes, the lay judges.
First instance.
Yes.
And recently there was some research being published about both in cases of asylum applications, but
Yeah.
also when it comes to just whether the how do you say, people in the process are women or men that affected certain of the jury members' decisions.
Interesting.
It was very interesting. Do you have any reflection on the services?
I haven't. I would just like to know what that. I would just like to write that down. That research. I would like to take a look at it.
I can get it for you.
Yeah. That would be great. No, but that's interesting because that's been a topic for discussion, obviously, for quite a long time. Doesn't matter if judges are male or female, for example, and like I think some research from the UK kind of suggests not really. And when I was talking to prosecutors back in Iceland, they would say the toughest judges you get are young women or women who have recently been made judges. They're never gonna find anybody guilty. And that's obviously very well known from a gender studies perspective, and it's very well known when you enter a field that is traditionally has been a male field. You make sure that you play by the rules of the game because you don't want to be excluded or somehow an outsider in that system. But then of course there have been what are they called now? They were talking about it in Umeå. These verdict, feminist justice verdict projects.
Feminist judges.
Right, when they have these kind of take old verdicts and give them to kind of feminist legal scholars who make alternative verdicts based on the same facts as the case and based on law, and can show how you can actually find another outcome to the same case with the same facts, but still in a legal way. So I think that's kind of interesting. But then we might see changes, for example, in Iceland, and I guess it's the same in Sweden. We only have 2 stages. We only have the district courts and then the Supreme Court, which is always the total embarrassment to all Icelandic lawyers. It's quite embarrassing only to have 2 stages. It's only 300,000 people. So. But they're actually changing that now. But so we only have 2 stages. And in the district courts, we have now almost the same amount male to female ratio. But in the Supreme Court, I think we have 1 woman out of 9 or something judges, Supreme Court judges. And there is indication that impacts. You need to have the critical mass, right? To have kind of an alternative culture, have the potential for an alternative culture to be developed within a court, right? So I think it's very important to have equal representation of men and women judges. So everybody's getting tired?
I think that project was called the Feminist Judgment Project.
Right.
And there is like a book, just Googled it. And
Yeah.
there's the book where they put them together. And
Right.
it's an ongoing project.
Right, yeah. And they've done this in Canada as well, I think, and Australia.
And Australia, UK, and Canada.
Yeah. would be nice to see something like that in the Nordic context. That would be really interesting. Maybe that's a project for Femdjur.
We actually talked about it. Like, we have so many ideas.
Yeah.
It would be cool to do something like that.
Right. That would be great. Yeah, congratulations on Femdjur. I think it's fantastic. Absolutely fantastic. Has it ever been done before? Have there been like a formal feminist organizations within law faculties in Sweden before? It has.
It's been like some students that organized here in Gothenburg like 10 years ago,
Yeah.
and then that just ran out in the sand.
Okay. Yeah.
So it has been like initiatives, but
Right.
it's hard to
Sustain them.
sustain them.
Yeah. Yeah. I look forward to watching you develop. Okay.
Did you know that they started in Lund as well?
Yes, exactly. I've heard about them in Lund and the Uppsala, Göteborg, and I heard about them in Lund as well. They started now. They're the last group, right?
Yeah,
To
just
start.
this semester they started in Lund.
Right, right. Yes, I have to check on them. Yeah, see what they're doing. It's great. Well, good. Thank you all so much.
Thank you.
Thank you very much.
Yeah, thank you.
Let's see if we got something here.